The gentleman from Henrico, Mr. Morrissey.
Thank you, Mr. Speaker. Mr. Speaker, I rise for the point of personal privilege.
Gentleman may proceed.
Thank you, Mr. Speaker. Mr. Speaker, yesterday, Delegate Marshall gave a passionate defense of traditional marriage, and he heaped a high level of criticism on our current Attorney General, Mark Herring, and he made references in support of his position to two things that I think myself and many Virginians would be anathema to myself and many Virginians. First of all, reading from his iPad, he said that the Virginia's marriage amendment preserves the legal benefit of civil marriage for those who form a particular kind of permanent exclusive union that is best suited for producing and rearing citizens for tomorrow. I would tell my friend and my colleague from Prince William that gay couples can also have permanent relationships, exclusive relationships, and they actually are adept at rearing children. He also said, quote, "The requirement of gender complementarity is unquestionably central to the purpose of civil marriage laws because it is precisely that union that produces children." I would suggest that Delegate Marshall's comments marginalized all of those marriages between a man and a woman where you can't produce a child because the couple that marries are aged, because the woman is infertile, because there's difficulty in carrying that child to term. I would suggest to the delegate that, yes, same-sex couples often marry even though they do not want to produce children. His second reference that I found troubling was his reference to the Dred Scott decision. As most of you know, Supreme Court Justice Roger Taney, who was a strict constructionist, in that decision, he said that African Americans did not qualify as citizens because the founders viewed them as an inferior order or second-class status. Interesting that he would use that decision to support his position when the Supreme Court of the United States this past June, in its ruling, banned parts of DOMA. And when it did that, it not only created an avenue for the states to rule on it, but the Supreme Court said that that act, and I'm quoting, relegates same-sex marriage to second-class citizens and humiliates tens of thousands of children now being raised by same-sex marriages. I would say to Delegate Marshall, look at what's happened in the last 6 months since that Supreme Court ruling. The number of states that now allow gay marriage has jumped from 12 to 18. Judges in New Mexico, Ohio, and surprisingly, Mormon-heavy Utah have all ruled in favor of same-sex marriage. Just 3 days before Christmas, Judge Robert Shelby in Utah said he struck down Utah's same-sex marriage. He said in a 53-page ruling that it violates gay and lesbian couples' rights to due process and equal protection under the 14th Amendment. He said that the state completely and utterly failed to show that same-sex marriage would affect sex marriages in any way, shape, or form. The state's refusal to dignify the family relationships of gay and lesbian citizens was just wrong, said the federal district court judge. We now have cases pending in Michigan. We have 2 federal lawsuits coming in Virginia. I would tell my colleague and friend from Prince William County that it is a freight train coming. It is a freight train coming. If he would only consider the following. If you look at every state court decision, every federal court decision that has come down since the Supreme Court ruling, there is, we know with absolute unwavering certainty that gay marriage is going to be allowed in this state and every state. It is a matter of time. It is a matter of time before Virginia gets ahead of the curve. Supreme Court did the right thing, and it said, we're going to leave it up to the states. But it's coming. There is not a state since then that has suggested that same-sex marriage isn't warranted. And I would tell my friend from Prince William County that a gay couple can love and nurture and raise a child just as well as any other heterosexual couple. Virginia has been wrong before. We were wrong when we supported the decision in Plessy versus Ferguson. We were wrong when we supported massive resistance. We were wrong with Virginia versus Loving, and we are wrong right now to oppose same-sex marriage. Thank you, Mr. Speaker.
Gentleman from Halifax, Mr. Edmonds.